Hello, dear people. Today we are going to discuss the will format as provided for under the Amendment of the Succession Act. We all know what a will is, but let's quickly define it. A will is a living person's expression of what they want to happen to their estate once they die. If you're 18 years and above, you can make a will. And in that will, you can state what you want to happen to whatever you own in that will. The format that has been provided in the amendment has 9 key things, and let us quickly go through them. My name is Fiona Orichiriza. I'm a lawyer. I practice with Sasiri and Company Advocates. And here we go. Number 1, you should list your children. And when we talk about children, these are both your biological and adopted children. Under the laws of adoption, once you adopt a child, that child essentially becomes your own. And when you're making a will and you're listing your children, you must as well list both the adopted and your biological children. When we talk about biological children, if you're married, you have to list those ones born in wedlock and those born out of wedlock. Number 2, if it's a man who is making a will and he has had a polygamous type of marriage, he will have to list all his wives. Number 2. Number 3, you have got to list all your dependents. These will include your siblings, your parents, if at the time of making the will, they depend on you, your relatives, or any other person that falls in the category of a dependent. Number 4, you have got to take stock of your properties and then you list them. These will include land, shares you own in companies, digital assets like cryptocurrencies, vehicles, bank accounts, employment, expected benefits, gratuity, pensions, and then the like. Then number 5 is where now you're going to do the actual distribution of property. Now, quite often people ask, can I make a will when I don't have fixed assets? Because when people hear property, they only think about fixed assets, land, houses, and the like. But it's not true. There are people who are going to make a will, and what they are disposing of, or what they are distributing, is furniture in their house, clothing, beddings, and the like. But I digress. Now, under distribution of property, you say land that I have here, I give to my daughter. Shares in this company, I give to my child. It is under this clause also where you can give a portion of your estate to a charitable cause, to the church, to an orphanage, or to any other person that you'd like. Under this clause, you have to make provisions for minors in respect of property. For example, you can say, the property which I hold at such and such a place, the rental income collected from there should be preserved or should be appropriated for the welfare of the minors. You will have to also appoint guardians for the children. You have to give property to your dependents or relatives and to your wife or to your husband. Now, under the new law, there is a new concept that says that if the home where you live with your wife or with your husband is, unless you provide for another comfortable, equal place for them to live, you cannot dispose of that matrimonial home or family home, for lack of a better word, under a will. And I think this is informed by the fact that sometimes this is where you live with your family, and when you die, now you don't want someone whom you've gifted your own house to come and evict your family when you've not made provisions. So unless you have made a specific and express provision of where your family can move to, if you give, if you distribute to a different person, for example, your family house where your family lives, now the will can be contested. Number 6, you have got to appoint executors of your will. An executor is someone who is appointed by a will to implement it. You do so by giving the full name or full names if there are more than one, and that empowers them to, if when you die, they will be in charge of applying for probate, which is a whole discussion at some other time, and then they'll have the power to distribute your estate according to the will. Number 7, you should state where you want to be buried. In the recent past, you have seen people die and different members of family go to court fighting over where they want to bury this person. If you're an organized person and you have left a will, you will do away with this kind of fracas, because now it will be clear that you stated where you want to be laid to rest. So I implore all of us to make a will and also mention a place where you want to be laid to rest. Number 8, you have got to make a list of the people or entities that you owe money. Sometimes people have loans, sometimes people have other obligations, and they find that they owe money to people, businesses, banks, and the like. So you have to make a list of the people and the entities you owe money and how they are going to be paid. In the example I usually like to give is, if you have a commercial property or a residential property that you use to generate income by renting it. Now, rental income from any of those properties, you can say that should be appropriated to deal with your debts. Number 9, you should also make a list of people and entities that owe you money. The reason you should do this is that quite often people die and a lot of money and properties or money that should come to their estate is lost in the wind, because no one knows where to follow this up. No one has this information. Sometimes these are personal agreements. You've not told anyone about it. But if it is in a will, then your executor will have where to start to go and demand for that money. Under this clause, you can also forgive the people who owe you money. You can say, owes me so and so much money, but I hereby forgive them that amount of money. Now, the new law requires that the testator should sign or put a thumb mark on each and every page of the will. So immediately after number 9, ordinarily there would be the date, the place where you're making this will, the testator's name, your signature, and the like. And then the next is attestation of the will, where the two people who are going to witness your will are going to sign. Now, the law also requires that the people who are attesting to your will should also sign or put a thumb mark on each and every page of the will. The 2 things you should know about a will in respect of the attestation requirement is that the person who is a beneficiary in a will is stopped from attesting to a will. That means that if you want to gift your property to someone in a will, they cannot be the same person witnessing a will for you. In error, you'll find children have witnessed their own parents' wills, yet this will be a ground to nullify a will. And once a will is nullified, that means that you are putting your estate under intestacy administration. So make sure that whoever is going to be a witness to your will or whoever is going to attest to the will is not a beneficiary in that will. The exception is where, for example, you have a main will and you have made a codicil. A codicil is like an additional will. You have a main will, and sometimes this is a bit confusing. Each will always say this is the last will and testament of so and so. But you can as well say it is a codicil in addition to the earlier will. So now someone who is a beneficiary in the earlier will can attest or witness in a codicil. The other thing that you should know is that each time you acquire a new property or you have a new child, or probably you marry a new wife, you should always make changes and make adjustments to capture the new state of affairs. I hope this has been very helpful to you. Give us a like, subscribe, and I implore you to make a will. Thank you so much.